Senate Committee on Criminal Justice will come to order. Clerk will call the roll.
Chair Flores,
Present.
Vice Chair Parker, Senator Hinojosa,
Present.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
A quorum is not present. There's committees meeting all morning, so people will be coming in and out. We will go through our business as efficiently and effectively as we can. So our agenda this morning contains legislation relating to emergency detention of people with mental illness so they can get court-ordered treatment. We are also considering changes to emergency court orders for better protect Texans, as well as how our justice system handles indigent defense and how our county probation programs work. Our goal is to make the Texas justice system the best in the nation, starting and ending with public safety and the rule of law. It is the intent of the chair to lay out the bills one at a time, take invited and public testimony, then vote on the bill if we have a quorum present. So if you intend to provide verbal testimony or would like to register a position on one or more bills, please register at one of the kiosks located behind the committee hearing room. When we do public testimony, we'll be limiting it to 2 minutes, and we're going to be strictly enforcing as much as possible unless there's questions from one of the members or at discretion of the chair. With that, any members, any questions? Senator Hagen, from Professor Hagenbooth, are present. Any questions? If not, well, let's get to work. So the chair calls out. Yes.
2370.
Chair lays out Senate Bill 2371. Chair sends up committee substitute for Senate Bill 2371. Is there any objection to adopting the committee substitute, Senate Bill 2371? Hearing none. So ordered. Recognize Senator Nichols to explain the bill and committee substitute.
Thank you, Mr. Chairman and members. The Financial Crimes Intelligence Center currently coordinates responses to skimming devices found on motor fuel payment terminals. Under current law, fuel pump operators are required to report discovered skimmers to both law enforcement and Texas Department of Licensing. However, similar skimming activity is now occurring in other types of electronic terminals, point-of-sale systems, virtual currency kiosks, and ATMs. This bill updates the Texas law to reflect this shift. It creates a similar reporting process for these other terminals, requiring merchants to report skimmers to law enforcement and the Financial Crimes Unit, and to disable the terminal until it can be inspected. This is faster, more effective investigations by the appropriate agencies. The committee substitute corrects a minor drafting error and eliminates language that initially exempted ATMs affiliated with federally insured institutions. Removing this exemption will ensure uniform enforcement. It was agreed to by the banks and everybody. I do have a witness from the Financial Crimes Unit to answer questions.
Thank you. Any questions for Senator Nichols, members? If not, the chair will open it up for invited testimony. Chair calls Adam Colby. You state your name, who do you represent, and any statement you wish to make.
One in the nation.
Adam Colby, Texas Financial Crimes Intelligence Center. Chairman Flores, Senators, thank you for the opportunity to address you this morning. My name is Adam Colby, and I am the Director and Chief Investigator for the Texas Financial Crimes Intelligence Center. I'm here to testify in favor of SB 2371. This bill is an expansion of the FCIC's authority over skimming devices as mandated in the Texas Business and Commerce Code. Currently, the code mandates that a merchant or technician must report the finding of a gas pump skimmer to the Texas Department of Licensing and Regulation. In turn, TDLR completes a thorough inspection report that was developed by the FCIC. This report is then forwarded to the FCIC. This arrangement has made it possible for the FCIC and TDLR to track gas pump skimming, allowing us to open cases in hotspots, deconflict cases among law enforcement, and obtain a better tactical understanding of gas pump skimming and trends. This bill seeks to do the same with ATM and point-of-sale skimming, with the exception that TDLR will not be involved in this, as they do not regulate these industries. Instead, the financial and retail sectors will report directly to the center electronically. This report should take less than 10 minutes for any merchant to complete or technician. This would instantaneously inform us that a skimmer has been located and put that information directly in front of our investigative team. Currently, there is no oversight by any agency when an ATM or point-of-sale skimmer is located. What we have learned is that in many cases, local law enforcement will not or cannot respond. When this happens, the skimmers are often disposed of or sent on to private industry for storage. This is evidence of a felony offense that is being disposed of. Once this evidence is gone, the chain of custody is broken and there is almost no chance for a wider investigation. Conversely, because there is no unified gathering of data, there is no way to be sure how extensive these crimes are. However, based on what is voluntarily reported to the FCIC, we can say that skimming in all forms is very widespread and almost exclusively tied to various foreign criminal organizations. This bill seeks to give the FCIC the ability to quantify the scope of the problem and implement solutions. When the FCIC is notified of an ATM skimmer, we are very often able to quickly throw field resources at the problem and effect arrests. Often, these cases lead to arrests in less than 72 hours. We harbor the expertise and know how to investigate these crimes and use methods and technology that are unavailable to other agencies. The criminals that commit these crimes are not local to any one jurisdiction and very often not even residents of a single state. And in fact, most of these criminals committing these crimes are not U.S. citizens and have no legal status in the United States. The transient nature of these criminal groups make it necessary to have centralized data on them. Criminals committing these crimes on one side of the state will pop up to commit the same crimes on the other side of the state. This creates conflicts with parallel investigations and one agency running up against another. The FCI has brought this under control with gas pump skimming, and I'm confident that we can do the same with ATM and point-of-sale skimming. We cannot do this without the authority for mandatory reporting. State law enforcement is flying in the blind with little exception, but this bill, enacted as law, will reverse this. Thank you for your time. I'm happy to answer any questions.
Thank you, members. Any questions? Any questions? Thank you for being here.
Thank you, sir.
Thank you for your testimony. There's no one else signed up for invited testimony. Invited testimony is now closed. Chair now opens up for public testimony. There's no one has signed up for public testimony. Is anyone here present who wishes to testify on, for, or against Senate Bill 2371? Hearing none. Public testimony is closed, and we'll hold this pending.
All right, thank you, Mr. Chairman. Let me also add that there are countries in South America who actually teach courses on how to do this in the United States, and there's franchises being set up as we speak.
Well, we thank you very much for bringing this bill forward to us, and it's in good shape.
Thank you.
Chair lays out Senate Bill 2581 and recognizes Senator Hancock to explain the bill.
Yeah, thank you, Mr. Chairman and members. Commissary accounts are used to fund various eligible projects and programs, personal items for inmates directed by Section 351.0415. Well, in 2001, the legislature passed House Bill 1890, which created a population bracket targeted specifically for Tarrant County at the time, and since then Dallas County has been brought into that due to population growth, and that was designed to address issues in Tarrant County relating to a couple of sheriffs that were abusing the commissary. And so what this bill is simply repeals that section, and we've worked with both our county judge, commissioner's court, sheriff's office to return this back to basically the way it's being conducted in every other county in the state. That's what it does.
Thank you. Any questions? Any questions, members? So hearing none, there's no one here for invited testimony, so if the chair now opens up for public testimony, and the chair calls Brian Hawthorne, Sheriff of Chambers County. Howdy. Good to see you, Sheriff. State your name, who you represent, and your position on the bill, and you know the drill.
Thank you, Mr. Chairman. I'm Brian Hawthorne. I'm the Chambers County Sheriff, but I'm here on behalf of the Sheriff's Association of Texas. I'm the first vice president. I'm the legislative director. First of all, thank you, Senator Hancock, for bringing this forward. This has been an issue that has taken place, and it's just the large counties that it's impacting. From a Sheriff's Association perspective, we don't care whether you're a county jail of 25 or a county jail of 10,000. We appreciate it when the legislature treats sheriffs equally. From the bigger to the smaller, obviously, there are certain bracketed bills that we appreciate for fiscal reasons. But for the fiscal reasons here, those sheriffs of Tarrant, Dallas, Harris County, they had to be able to operate their commissary in the same manner that I operate my commissary and the rest of us do in the other 241 jails. So short and brief, and thank you, senators, for bringing this forward.
Thank you, thank you. Senator Hinojosa.
Thank you, Mr. Chairman. I guess what the sheriff's departments will still be have to be audited at least once a year.
Yes.
Yes, sir. We are audited by the auditor. The county auditor audits. And also, I think it's important to note that there's very specific limitations to this money. We can't just arbitrarily go throw it at anything. It is designed for anything that's going to benefit the inmate. Many of us use it for training issues to make sure that our staff are treating inmates properly, but it's definitely accounted for money and has to be properly spent.
And one more question. I guess the county commissioners court, if they so wish, can audit more often than that.
Yes, they do have the ability to audit it, and many of us, for example, I may use to buy a new jail van to transport them to the doctor or what have you, and I always let them know that here's how we're spending the money. So most sheriffs are very forthcoming exactly how that money's being spent, and it's at the benefit of the inmate itself.
You're not going to take a vacation out to Hawaii, are you?
No, sir, we don't do that.
Thank you, sir.
All right.
You can't buy a helicopter either, which is why it got withdrawn. Why
That is
this
correct.
code came in. A helicopter was purchased without the knowledge of the commissioner's court that subsequently crashed, and then they found out about it, and that's why we had this put in place. It's back in the 90s, but, you know, well,
Yep.
we like Sheriff Wayborn, and court likes Wayborn, and so we're trying to get parity with every other county in the state.
Right, and the Sheriff's Association appreciates a 30-year problem that needs to be rectified, and
There's a new sheriff in town.
that is correct. Thank you. Thank you.
Thank you. Thank you very much. Appreciate you being here.
No, thank you, Senator. I appreciate you.
We go way back. Okay, thank you. That's it. Where is anyone else present that wishes to testify on, for, or against Senate Bill 2581? Hearing none, public testimony is closed, and we'll hold this bill pending. Show Senator Miles is present, show Senator Huffman is present, and the quorum is established. Are you ready, Madam Chair? Sure. All of them.
Kind of ready. You just tell me which one, I'll get going.
Chair lays out Senate Bill 330 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Members of the 87th Legislature passed Senate Bill 23, which was a priority bill, which requires counties with a population over 1 million to receive voter approval before cutting their law enforcement's budget. However, law enforcement doesn't play the sole role in the criminal justice system. Prosecutors play a critical role, as well as they are charged with obtaining justice for victims of crime and should be treated no differently than law enforcement. Senate Bill 330 adds to Senate Bill 23 from the 87th Legislature by adding prosecutors' offices to the provisions of Chapter 120 of the Local Government Code. Accordingly, a local government must secure voter approval before passing a budget that reduces regular funding for a prosecutor's office compared to the previous fiscal year as a percentage of the total annual budget. Regrettably, we continue to see some local officials attempt to cut criminal justice funding to score political points without regard to the consequences. Decreasing funding for prosecutor offices only inhibits their ability to prosecute cases and thus delay the prosecution of criminals in our communities. Texans deserve to feel safe, and this bill ensures that local voters have input in these critical public safety decisions. That's it.
Members, any questions to Senator Huffman?
We've done this before.
Hearing no questions, turn now open for invited testimony. There's no one signed up for invited testimony, so I close invited testimony. Now open for public testimony. The chair calls Alicia Castillo.
Good morning.
Good morning. Your name, who you represented, your position on the bill, and you have 2 minutes.
Yes, Alicia Castillo. I represent the Texas Civil Rights Project, and I'm in opposition to SB 330. And this is because local governments, we believe, are uniquely positioned to assess and respond effectively to the needs of their communities, their district needs, the priorities that they have, and county officials directly accountable to their constituents must retain some level of flexibility to allocate resources based on evolving local needs. SB 330, we feel, undermines this essential principle of governance by imposing restrictive state-level oversight over routine budgetary decisions. And then additionally requiring costly and cumbersome countywide elections for any budget adjustments concerning law enforcement or prosecutorial funding is not only inefficient, but also diverts critical resources away from essential community needs. This approach, in our view, disregards the specialized knowledge and insights of local leaders who understand best how to balance prosecutions with more comprehensive public safety services like healthcare, housing, infrastructure. And we've already seen the harmful impacts of legislation like this. We know when cities, when this legislature significantly restricted cities from allocating or reallocating resources from police budgets, cities like mine were impeded in our efforts to innovate and address root causes of crime through mental health initiatives, housing, and community support programs. This bill expands this troubling precedent in counties, stifling their ability to implement comprehensive public safety strategies tailored to specific needs. So we feel that this represents an unnecessary and damaging infringement on local autonomy, and for that reason we oppose. Thank you for your consideration.
Thank you for your testimony. Any questions, members? Thank you. Seeing no one else signed up for public testimony, is there anyone here? Senator Hinojosa.
Just a general comment, and Senator Huffman, I know from experience many of the prosecutor's office have challenges in trying to attract young prosecutors to the office because of the low pay, which is reduced by the commissioner's court, and they continue having a high turnover and very inexperienced prosecutors in the different county courts and district courts in prosecuting crime. So I'm very familiar with this issue. I talked to my DA in Hidalgo County, and they do need this type of help where they can at least fund and hire prosecutors with a living wage.
Right. And as you know, Senator Hinojosa, last session with the rural law enforcement, we did add the prosecutors to try to help with the salary, in some of the more rural parts of the state. But it continues to be an issue. And of course, this bill goes to populations. This really goes to the urban counties.
Correct.
Where there seems to be more of an issue of trying, and I do understand it's a balancing of budgets. There are issues there. There are other priorities, but the public wants public safety to be a top priority in their communities. They're crying for this, and we hear it throughout the state. And that bill helps to facilitate this.
Good bill.
Any other questions? Is there anyone else present who wishes to testify on, for, or against Senate Bill 330?
Someone has his hand. I don't know.
Do you have your card?
I did not sign up, sir, because I didn't.
Do you have the card?
Happen to see him raise his hand.
State your name, who you represent, your
Sure.
position on the bill, and you have 2 minutes.
Chair Flores, I want to thank you for allowing me to speak. I'm Guy Herman. I happen to be the Travis County Probate Court Judge, and I didn't sign up for this, and I apologize to our senator for not doing that because I was curious about what it was, and now I know what it was. I'm in support of this bill, and I'll tell you why, because we have a lot of not only criminal issues that need to be addressed, but we also have prosecutors that don't have the money in their budgets to prosecute exploitation of the elderly and the disabled people by third parties, and we need to have this kind of money in these budgets and continue to fund these prosecutors' offices. And I've been working in this area for more than 40 years.
Thank you for your service.
And we need to do this, and I'll sign up as soon as they give me the card.
Yeah, we're going to need to do that, but thank you for your service, and thank you for your comments. Any questions, members? Seeing there's no one else, no more public testimony is closed, and we will hold Senate Bill 330 as pending. Chair lays out Senate Bill 663. Chair sends up committee substitute for Senate Bill 663. Is there any objection to adopting the committee substitute for Senate Bill 663? Hearing none, so ordered. Recognize Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Members, the budget process for the Community Supervision and Corrections Departments include in-depth standards, guidelines, reporting, and formatting requirements set by TDCJ, the Community Justice and Assistance Division of TDCJ. It can be challenging for a judge to perform the court's primary adjudicative responsibilities for managing a large docket while also taking on the administrative responsibility for a department's budget and strategic plan. For example, the Harris County CSCD has over 30 detailed budgets across four different funding lines and outside funding sources. To ensure local community supervision and corrections departments are not overlooked, Senate Bill 663 removes the requirement for a CSCD budget to be presented to the district judges of a county for approval. The bill still requires their budgets to be submitted to the district judges for review, but no longer requires approval. The TDCJ Community Justice and Assistance Division already has a responsibility to monitor and audit CSCD compliance with all statutory requirements. Removing this approval will enable district judges to focus on their primary responsibilities while also ensuring that the community supervision and corrections departments are not unduly interrupted. The committee substitute just makes minor clarifications and conforming changes as suggested by some of the community supervision and corrections departments directors as we work through preparing this bill for committee.
Members, any questions? Senator Huffman, any questions? If not, invited testimony is now open. Chair calls Dr. Teresa May.
Good morning, Chairman, members, Chair Huffman. Thank you for filing this bill. I think it'll be a big help for CSCDs. All right. So, as Senator Huffman said, our funding is incredibly complicated. In Harris County, I have 30 different budgets across 4 funding lines. When I meet with judges, they sit there very patiently, but they're so ready to leave the room. And a lot of them have told me, we have no idea. We don't understand. And I can break it down a million ways, but I get new judges almost every 2 years, and it is near impossible. This last time I went up for budget approval, and I've had it happen in the past, in another county I worked in and here, they've looked at me and said, why do we do this? Because we really don't know. We really don't understand all this. And Senator Huffman's learned all too well. It's incredibly complicated with all the ins and outs. So this makes a lot of sense for many, many reasons, but that is probably one of the fundamental reasons. It's a lot. And so essentially what she did is it's changing the approval. So right now how it works, the director for the department prepares the budget. So this bill doesn't preclude you from talking to your judges, which I do, and your local stakeholders to make sure whatever you're writing in your budget fits the needs. My judges want to know that Senator Huffman's going to like this. My facilities are funded, that I have staffing appropriate, those sorts of things. But again, they look at me and want to know how quick I can get done with the budget. So we do meet, we do talk about it, and it's still very much, you're going to write a budget that fits your needs. So there is local, every department's different in a decentralized system. So the director's job is to make sure, we keep our judges informed. And so we answer the questions they want to know. And it's really about that. You know, what resources are available? What can you do? You know, where can we send people? Those sorts of things. How can we reduce wait lists? Those are the things I hear. So the bill has our oversight agency, which is the Texas Department of Criminal Justice, Community Justice Assistance Division, which is a mouthful, TDCJ, CJAD, which I know y'all are all familiar with, approved the budget. We submit it to TDCJ, they approve the budget, and then the budget gets shared with the judges for review if they're interested, but it's the approved budget, which makes a whole lot of sense. TDCJ is the regulatory authority or the agency that sets the standards for us, sets the parameters. They literally set the framework for how we do our budgets. They are charged with monitoring our compliance with not only data reporting for the programs we run and everything that comes through departments, but they also get quarterly financials. They review our budgets. So now, you know, the law requires director write the budget, judges to approve the budget, even though, you know, they really don't completely know the budget, and then also submit it to TDCJ for approval. So the other thing that can happen is the budget, let's just say TDCJ checks it, because they're the ones that know what's an allowable expense, what's permissible. You know, state funds have specific things they're supposed to be spent for. There are things we cannot spend money for. There's a financial management manual that is probably, I don't know how many pages, but Carrie will know. But, you know, you're in a situation where they're going to check all of those things. They're going to make sure you balanced your budget. They're going to make sure it makes sense. It complies with the law. It does everything it's supposed to do. And they do know if you know what you're doing. So essentially, the judges are going to get a vetted budget. If they want to look at it, ask questions, certainly. You know, no problem, they can. So it basically increases the efficiency of what we do. Right now, you know, we also have a lot of brand-new directors who aren't familiar with all the rules and regulations, and it takes some time to learn. If the state has to send, or TDCJ, CJAD has to send back a budget because it's not accurate, then the director's got to go all the way back through approval with their board of judges again, and till this thing is corrected. Sometimes that could drag out and take a long time. And as Senator Huffman mentioned, you know, one of the things that can happen, you know, usually, you know, after a session ends, TDCJ, CJAD then distributes the funding for CSCDs. That takes a minute, and you really don't have a ton of time between the beginning of the fiscal year, September 1st, and when all of this gets sorted out and you prepare your budgets, and it's, you can imagine 30 budgets, that takes a minute as well. So literally you could end up starting the fiscal year not being able to do your payroll because you haven't passed a budget yet, if you're going back and forth. So this does a great job of solving those problems and ensuring that the budget is accurate, it's been vetted, and it really does clean up a problem that we've had for quite some time. There's a couple of other things. I provided some written testimony. I'm not going to read it to you. I know y'all are probably happy about that, like my judges are happy when I don't go through every line of the budget, but
I'm beginning to feel like one of those district judges there sitting in the room.
yeah, are you? So Senator Hosa, I will take that as wrapping up my testimony. One thing I just want to emphasize, because, you know, even a discussion among directors, and there's 122 of us, some people are a little confused. They're thinking it's taking away something from the judges, and it's not. You're still writing the budget for your local control. You can still sit down and meet with your judges, talk about your budget. We are still under the judiciary in Chapter 76. None of that has changed. The judges still appoint you, so they are still your boss. They appoint your fiscal officer, so you're very much still in line.
Well, thank
Okay.
you. We appreciate you. And one more time, your name and who you represent for the record.
Okay, it's Teresa May, and I am the Director of Harris County CSCD, and I'm speaking on behalf of myself as CSCD Director and on behalf of the Texas Probation Association in favor of the budget.
Thank you very much.
I'm sorry, in favor of the bill.
Thank you. Thank you for your testimony. Members, any questions? Any more questions? Thank you very much for taking the time to come visit with us.
Thank you, Chair. Thank you, sir.
Yes. And so the chair calls for invited testimony Allison Martinez. Allison Martinez. If you state your name and who you represent, and you may proceed.
Good morning, Chair Flores and members of the Criminal Justice Committee. My name is Allison Martinez, and I am the Director of the Webb and Zapata County CSCD in Laredo, Texas. I am here on behalf of the Texas Probation Association in support of Senate Bill 663. So before I begin, I want to express my gratitude to Senator Huffman and her legislative staff for their leadership in authoring and presenting this bill. Their dedication to strengthening community supervision and their thoughtful approach to resolving longstanding structural issues within our system are deeply appreciated by directors across the state. Senate Bill 663 addresses an area of community supervision administration that has long needed clarity and efficiency. As a third-year director, I all too well know just the intricacies of all of the things that we have to do to get our budgets approved and strategic plans across. Currently, directors must submit these budgets to their local board of judges for approval before submitting them to TDCJ, CJAD, even though CJAD is ultimately responsible for ensuring compliance with state standards and appropriate use of funding. This sequence creates unnecessary inefficiencies. If the Board of Judges approves a budget or strategic plan that is later rejected by CJAD, directors are forced into a frustrating loop of revisions and reapprovals, sometimes multiple times. It delays the process, but also places directors in difficult positions with both the courts and the state. Moreover, the current law creates confusion about judicial responsibilities. Many judges are unsure about their role in CSCD oversight, especially since HB 1326 passed in the 79th legislature that removed judges from most operational and fiscal responsibilities related to CSCDs. Yet, they are still tasked with budget approval, something that at times leads to disagreements over expenditures that may not align with statutory requirements or appropriations. Senate Bill 663 provides a thoughtful solution and maintains the judiciary's role in reviewing budgets and strategic plans, but shifts that review to after CJAD has conducted its formal approval. It preserves transparency and communication with the courts while ensuring that budgets meet all legal and fiscal standards before being implemented. Let me be clear, this bill does not diminish collaboration with the judiciary. Directors will still need to meet with judges to discuss local needs and priorities. Judges will continue to establish CSCDs and appoint directors and fiscal officers. They'll still be my bosses and bosses of all directors across the state. What Senate Bill 663 does is bring the process into better alignment with current statute, reduce delays, and clarify roles so we can serve our communities more effectively. Thank you for your time, and I'm open to any questions if you have any.
Thank you, members. Any questions? Thank you for taking the time to come up all the way up from Laredo.
Yeah,
And thank you very much.
thank you.
There's no one else signed up for invited testimony. Invited testimony is now closed. Chair now opens up for public testimony. There's no one signed up for public testimony. Anyone here wishes to testify on, for, or against Senate Bill 663? Hearing none, public testimony is closed, and we'll hold the bill pending. Chair now lays out Senate Bill 1020. Chair sends up committee substitute for Senate Bill 1020. Is there any objection to adopting the committee substitute for Senate Bill 1020? Hearing none, so ordered. Recognize Senator Huffman to explain the bill and the committee substitute.
Thank you, Mr. Chairman and members. Members, for the past few years, the Harris County District Attorney's Office has had problems obtaining ankle monitor data and records. Certain Harris County judges, let me move my stuff here, sorry. Certain Harris County judges determined that these records are considered judicial work product and suggested that the judges could withhold such information from prosecutors and law enforcement. These officials were also of the opinion that defense lawyers enjoy the right to be apprised of the state's request for their clients' GPS data, even when requested as evidence of a new crime. Harris County officials then advised the director of Harris County Pretrial Services not to release these records without a court order. This created a system in Harris County where different courts had different approaches when dealing with requests for ankle monitor records. Senate Bill 1020 clarifies the information sharing process for personal bond and supervision offices to actively maintain and share information related to ankle monitor violations with the court in which the case presides. The local personal bond office would then be responsible for updating the individual's record of said violations and distributing that information to both the state and the accused person's attorney. Finally, to ensure this information is accessible, the bill clarifies that this information does not fall under the umbrella of judicial work product. Unfortunately, we find ourselves having to legislate in response to Harris County's attempt to circumvent legislative intent and undermine the criminal justice system. And the committee substitute changes the notification requirement to mandate immediate reporting upon a reasonable belief that a violation has occurred. Additionally, it clarifies that the notification must be made to the court or magistrate with jurisdiction over the case. And it grants the Community Supervision and Corrections Department the authority to share the local information of a violating individual with law enforcement as well. Lastly, the committee substitute expands the notification requirements to include individuals released on cash bond. And again, these are individuals either on personal or cash bond who have been ordered to have an ankle monitor per court order, and there are violations, and the courts have, for some reason, determined they don't have to give that information to law enforcement or the prosecutors so that they can prosecute the crime of tampering with your leg monitor or ankle monitor, which passed last session. So it's impossible for the crime to be prosecuted without information.
Senator Miles.
Makes no sense at all.
Hey, Mr. Chairman. Madam Chair,
Yes.
This is more about data than the actual tampering with.
Well, they need the data to be able to tell if, in fact, it had been tampered with. Because
I support what you're doing here.
Yes.
But I was wondering if we should just change this to remove or deactivate, or is it more just about the data transfer?
Well, the defendant has no personal right to privacy on the information on their ankle monitor when it's been ordered by a court, because as a condition of bond, they are allowed to be, on bond or be released subject to
It's a privilege.
the ankle monitor and the information that can be gathered and obtained. And really, it's about, did they stay in a certain area? Did they leave the county? Were they out after a curfew, which sometimes they have, there's different conditions.
So
Did they go someplace other than to their work where they were supposed to go? So it's about tampering, but it's also violations of
So do we, instead of saying tampering, do we just want to say deactivate or remove? Because tampering is kind
I'll
of
take
broad.
a look at what you're suggesting. I couldn't just agree offhand. I have to come study it.
because tampering is kind of broad.
I'll take a look at it.
And what I'm saying is, let's call it what it is. They're trying to remove it or they're trying to deactivate it. So I'd like to, if we can, think about it.
I'll look at it.
Change it to, deactivate or removing, and make it specifically what we're trying to do here.
Still want the data available, though.
Okay, so it is about the data.
Well, it's part of the information that could prove a violation of a court order, yes.
Okay. I'm concerned, as being house trained, there may be a two-subject point of order in the House. That's all I'm trying to help you with your bill get through.
I think the caption is broad enough, but I'll double-check the caption.
Okay, Madam Chair.
Thank you. Senator Hinojosa.
Just a real quick point. Thank you, Mr. Chairman. I guess you have district courts that apply law in an inconsistent way.
Correct.
Some say it's confidential, some say it's not.
Right, and they're using the excuse of a judicial work product, which I'm not really, that is puzzling to me, but some of them are saying that. Thank you, sir.
Thank you. Any other questions, members? So Senator King is present.
No. Yeah.
So the chair now opens up for invited testimony. The chair calls Andy Kahn and Kim Ogg. Good morning.
Good morning.
We'll start with you and your name, who you represent, and you may begin.
Yes, sir. Senators, good morning, and thank you for having us. My name is Kim Ogg. I'm an attorney of almost 38 years. I'm board certified in the area of criminal law, and for the past 8 years, I was the Harris County District Attorney. Effective September 1, 2023, the Texas Penal Code made it a state jail felony for individuals accused of crimes or convicted, anybody wearing an electronic monitor, to be charged with a new crime if they tampered, removed, disabled the ankle monitor. I will tell you the public depends and relies upon the representations of the courts that this makes people safer by having supervised electronic monitoring while somebody's out on bail. After a case called Urson, a deputy that was murdered in Harris County by two individuals on bond for murder and capital murder, I testified before this Senate committee at a hearing where I discussed how law enforcement had solved the crime. They solved who the murderers were by looking at ankle monitor records of individuals in the specific area where Deputy Urson was murdered. So it was used not just for supervision, but for investigation of new crimes. And that was the need of prosecutors and law enforcement, both to prove crimes that were being violations of bond or this removal of the ankle monitor as a new crime or an ancillary crime, in this case, a capital murder of a police officer. After that, we noticed that certain courts in Harris County were refusing to allow access by law enforcement to those GPS records. We've learned that in Harris County, there are three categories that are labeled GPS, ankle monitors, and curfew. But really, they all involve the mechanism of an ankle monitor. Mr. Kahn will testify as to some stats that he's found that show you how prevalent the use of these by judges are. And we often hear the public told this makes us safer. In truth, when we can't get to these records without a judicial order, it delays and sometimes halts investigations and prosecutions of new crimes and bond violations. And at the time that I wrote the letters complaining about this to Senator Huffman, thank you for filing this bill, Senator, all 39 courts had different rules about how to obtain an order. All of this created delay, and the lack of uniformity created difficulty for our lawyers in trying to obtain the records. It created even greater difficulty for law enforcement agencies. So because of that, we feel that the withholding of such evidence is counterproductive to public safety. The classification of it as a judicial work product is misplaced and would ask for an exception through this bill to the consideration of this evidence as judicial work product. It's evidence. It should be obtainable through a grand jury subpoena, through a warrant, or really even through professional courtesy in the courts. And so I'm testifying today in support of SB 1020.
Thank you. Mr. Kahn?
Good morning. My name's Andy Kahn. I'm Director of Victim Services for Crime Stoppers of Houston, and I'm here representing Crime Stoppers and myself in support of Senate Bill 1020. I took a look at some of the numbers that are on Harris County Pretrial Services annual report, and I'm just going to read off the numbers because it's absolutely alarming. They actually blew me away, the numbers, how it escalated. So in 2019, you had roughly about 600 people on some form of an ankle monitor, whether it be electronic monitoring or a curfew. 2020, you had about 2,400, okay? 2021, you had about 7,200. 2023, here's where the big, if you bought stock in GPS or ankle monitors, you got one heck of an investment in 2023 because we're looking at about 4,700. That's 4,700 defendants on some form of an ankle monitor. And in 2024, this is where you really made a killing on because you basically had 11,000. That's just in Harris County. You had 11,000 individuals on bond that are on some form of an ankle monitor. And we all see this, he's going to be put on an ankle monitor and everybody's, oh, great, they're going to be watched. The reality is an ankle monitor is only as good as the person who wants to honor it. If they want to honor it, it's the greatest tool in the world. If they don't want to honor it, nothing really is going to prevent them from removing, destroying, or tampering. It is imperative to have this information made available to law enforcement, to prosecutors immediately. I could never figure out why you had to jump through hoops just to get information on defendants who are in violation of their ankle monitor. If I broke out of prison, all hell breaks loose. The whole world knows, right? But if I'm escaping, which is what you're doing when you're removing or an ankle monitor, it's a form of escape, we have to sit back and wait. Time is of the essence right now. If you're going to remove an ankle monitor, that means you're up to no good. And it's imperative that we get that information now, not 48 hours, not whatever, how long it takes to get that information. And that's why we wholeheartedly support Senate Bill 1020. The numbers speak for itself.
Thank you, members. Any questions? Thank you both for being here. Good to see you. Thank you. There being no one else registered for invited testimony is now closed. The chair now opens for public testimony. The chair calls Dr. Teresa May. Yep. Very good. Then there's no one else registered to for public testimony. Is there anyone here that wishes to testify on, for, or against Senate Bill 1020? Hearing none, public testimony is closed, and we'll hold this pending. And Chair lays out Senate Bill 1164 by Senator Zaffarini. Chair sends up committee substitute for Senate Bill 1164. Is there any objection to adopting the committee substitute for Senate Bill 1164? Hearing none, so ordered. I recognize Senator Zaffarini to explain the bill and the committee substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 1164 relates to emergency detention of certain persons evidencing mental illness and to court-ordered inpatient and extended mental health services. It is a recommendation of the Texas Judicial Commission on Mental Health, which is chaired by Justice Jane Bland and of which Senator Joan Huffman is a member. It works with judges, law enforcement, healthcare professionals, and policymakers to develop legislative solutions that improve Texas' mental health system. Based on the Commission's findings, Senate Bill 1164 would improve emergency detention procedures, clarify officer responsibilities, ensure jurisdictional consistency, and expand criteria for early intervention in severe mental health cases. These changes would not only strengthen public safety and judicial efficiency, but also provide persons experiencing mental health crisis better access to timely and appropriate care. Generally then, Senate Bill 1164 would update the form peace officers are required to use when carrying out emergency detentions without warrants, clarify peace officers do not have to remain at the receiving facility after presenting persons for emergency detention without a warrant, and provide that applications for court-ordered mental health services may be filed either in the counties in which persons are apprehended or in the counties in which they are located at the time of filing. The committee substitute differs from Senate Bill 1164 as filed originally in that it would add whether persons' lack of capacity to recognize their mental health symptoms or to appreciate the risks and benefits of treatments as a factor for emergency detention. Maintained persons must be an immediate risk to themselves or others to qualify for emergency detention, and eliminate a prompt on peace officers' emergent detention intake forms requiring firearms. This was requested by Chairman Flores. And we do have a resource witness from the commission.
Members, any questions? So there's no one signed up for,
We should have.
there's a resource. Chair calls up Christy Taylor. Christy Taylor.
Thank you, Chair Flores.
Your name and who you represent.
Christy Taylor, the Executive Director of the Texas Judicial Commission on Mental Health.
Here is a resource. Members, you have any questions? Any questions? You're not born 300 years ago, are you? That's okay.
Maybe Mike Ward.
Yes, maybe Mike. Any questions? Thank you very much. Thank you for being here as a resource. Chair now opens up for public testimony. The chair calls Walter Macias, Larry Satterwhite, and Jan Lightfoot. And a chair also calls Judge Brent Carr. Sir Walter Macias, Larry Satterwhite, Jan Lightfoot, and Judge Brent Carr.
Hello, everyone. My name is Walter Macias. I'm from San Antonio, Texas, and I'm testifying on behalf of NAMI in support of Senate Bill SB 1164. I believe my family could have benefited from the proposed SB 1164 bill that could have averted the tragic ending of my mother and my brother. At age 21, my brother Fernando suffered a mental breakdown and had to cease studies at the University of Houston and was unable to work due to manic depressive bipolar disorder. My mother cared for him for the next 42 years while also working as secretary to the dean at Our Lady of the Lake University. Due to the severity of his illness, we sometimes turned to law enforcement for help, but laws protecting his rights also allowed him to refuse necessary emergency detention. SB 1164 could have been a game changer. With time, he became my mother's caregiver. She was suffering from dementia and confined to a wheelchair at age 84. He was suffering from, my brother was suffering from kidney failure and mental illness. He refused both dialysis and help with my mother's care. We reached out to law enforcement and APS. Again, his rights allowed him to refuse treatment, and my mother was left in his care. SB 1164 could have made a positive difference. Eventually, Fernando, my brother, deteriorated to the point of believing that he needed protection from imminent invasion of space aliens. He said he had been trying to obtain a purchase of an AR-15 rifle, but was going to keep trying. I immediately told the APS caseworker expecting intervention. Instead, she failed to answer or return calls for days. I contacted her supervisor, who told me that the case had been inexplicably closed. Valuable time had been wasted. I filed for a wellness check and was granted. Deputies arrived and were denied access. They entered through sorry.
Go ahead and finish your sentence,
Okay.
sir.
They went ahead and entered through a back door, they entered through a back door and were shot at. A 28-hour standoff ensued, ending in gunfire. In the end, my brother was wounded, and my mother was, who was caught in the crossfire, was dead at the hands of law enforcement. At SB 1164 bin law, the officer could have enforced emergency detention to save them both. My brother was taken into custody and treated for physical wounds, but because there were no beds available at the state hospital, he languished at the county jail for 10 months until he died from renal failure. SB 1164 could have allowed them to take him in for proper evaluation and treatment. Lacking proper psychiatric care, my brother died while in custody without being adjudicated. He did not have a criminal record prior to this event. Thank you for your time.
Thank you for taking the time to come from San Antonio. Your Honor.
Good morning, Chairman Flores, members of the committee, Senator Zaffarini. Thank you again for working with us on this legislation. I'm Brent Carr. I'm here today representing myself. I have worked with the Judicial Commission on Mental Health. Most of the changes that are recommended are pretty much just common sense to make things flow a little bit more smoothly. But I guess the one that will probably receive the most attention is the one that we just heard the testimony about. I was on the bench for 32 years. I started the first mental health diversion court in Texas in 2003. And I had a general interest in this area, and over my many years, I have encountered many people who are smart. One was a close friend of mine, a lawyer. I used to play tennis with him. He developed schizophrenia. He ended up pointing guns at police officers, and he was shot and killed. Had another fella in Bedford, Texas, who lived under a bridge. He would probably be on the cover of, if you just looked at him, of most Men's Health magazines. He was very well trim and cut, but he had profound schizophrenia and bipolar disorder. And if you happened to cross the bridge on a day that he was there, he would come out and probably smack you in the face, and you would felt like, judging from the size of his arms, that you'd probably been hit by a train. So he was taken into custody. We talked with him, with his attorney present, and we talked for hours with this guy, trying to convince him that he needed some help, and even the victim recognized that and was willing to work with him. There are many of these situations, and I certainly encourage the passage of this bill. Thank you.
Thank you for being here. You may proceed.
Thank you, Senator Flores, senators, and thank you, Dean Zaffarini, for bringing this bill forward, 1164, which, as a representative of law enforcement, we are in support of. My name is Larry Satterwhite. I am the Director of Public Safety and Homeland Security for the City of Houston in Mayor John Whitmire's administration. I am a veteran of 34 years with the Houston Police Department and retired last August as the interim chief of police. I led the Houston Police Department through many challenges, and upon my retirement, Mayor Whitmire asked me to take over as Director of Public Safety and Homeland Security and continue to protect the public and work to improve everyone's quality of life. One of the primary goals of Mayor Whitmire's administration is to end street homelessness in Houston and Harris County, and he asked me to help reach his goal. After 34 years, I have extensive experience working with our homeless. I am here today to express my support for SB 1164 filed by Senator Zaffarini. For far too long, I have witnessed our unhoused population suffer from mental illness and substance abuse. They exist often in their own human waste and are victimized by predators and also prey upon others who are weaker. They live a tragic life and bring tragedy and suffering to those around them. Ultimately, they die on our streets by the hundreds every year. Sadly, many of them do not even recognize their own illness and perilous situation. They refuse offers of help, leaving law enforcement and first responders with no option but to wait until they commit a crime or fall into crisis. It can feel as if we force our unhoused or our homeless to become criminals before they can be treated. We estimate more than 1,000 unhoused on our streets in Houston today, and more than 300 suffer from serious mental illness. Roughly 30% of the inmates in the Harris County Joint Processing Center suffer from mental illness, and many of them are homeless. We want to intervene before the person suffering from mental illness becomes a victim, harms someone else, or goes into crisis and harms a police officer responding to the chaos. We need more funding for hospital beds and medical professionals for our mentally ill. We need funding to provide step-down care and re-entry from our jails so that our mentally ill do not end up back on the streets and repeating the cycle. We need the laws to change, like SB 1164, to provide the ability for more individuals, to move individuals long identified and diagnosed with mental illness off the streets and into effective managed care. To be clear, we are not asking for the authority to detain just anyone who appears to be homeless. We are asking for the authority and the support to get longer-term help to those who have a history of mental illness and are well known to law enforcement, first responders, and our medical community. Our courts and probate judges need more latitude to order longer-term treatments so these patients can improve and thrive. This is our best chance to save their lives and improve the quality of life for all.
Thank you. Thank you for coming from Houston. Any other questions?
Mr. Chairman, one micro comment.
Please. You're recognized.
Also wanted to assure the committee that by adding this new provision, as Senator Zaffarini knows, you're still looping back to a requirement that this failure to recognize is so extreme that it's still presenting a risk of substantial harm to self or others or deterioration to a point to where the person could suffer injury or substantial injury. So it's not just a willy-nilly expansion of the statute. It is still tied to very long-standing and recognized in many other states, and this provision will stay within its lane. It will self-effectuate itself, and it will provide a treatment to a class of citizens that is sorely lacking at the moment.
Thank you, Your Honor. Any other questions? Thank you all. Senator Huffman.
And I'm very supportive of Senator Zaffarini's legislation. I'm just, do you think the language is strong enough that it's actually going to solve some of these issues?
Well, like
looking
another
at it.
part of this bill, where the answer is yes.
Okay.
Where, like another part of this bill where we had an oversight in the last session, since Christy Taylor's here, I'll let her take the blame. But you know, we recognize that this is a necessary expansion, and obviously we may have to come back and tweak it again at a future session. But I think it would.
And that's my concern, because I know that sometimes the judges will look at that and they're very reluctant to keep someone, you know, in custody if they don't want to be there and they haven't committed a crime. To the gentleman in the center's point, you said your brother never had any kind of criminal convictions at all. So, you know, there are individuals who manage to skirt on the outside, and some of the homeless people are like that. They're not really committing necessarily going through the justice system. And gentleman I don't remember her name, I'm sorry, but
Walter Macias.
Walter, thank you very much for sharing your story. It's a tragic story. Unfortunately, it's not necessarily totally uncommon. You know, if we look throughout the state, there are going to be other tragic stories like that where it's somehow we failed to you and your family, but not without the best of intentions by everyone. Law enforcement, judges, I'm sure law enforcement included, had probably been to your home many, many times over the years, right? Right, yeah.
May I add a little bit more, Senator? Yes, sir.
You're recognized.
Yes, I would also add, the only thing, obviously, is that the requirement of imminent danger, meaning in most people's minds, would indicate that they are about to severely harm themselves or severely harm someone else.
Exactly.
And I will say that we would like to intervene before it gets to that point.
Right.
And that's the idea, because we know these individuals. We have long histories with them, and we know their diagnosis. So we would rather get to them before it gets to that point, which is at that point, it becomes very dangerous for the first responders and the public when they're responding to that scene. So
that's exactly why I asked the question, because I understand where there's that place where they're not about to kill themselves or they're not about to hit somebody on a bridge or something. But your experience, and you know they've been out there, law enforcement knows them, they know they're right on the edge there of something happening, but there's not anything concrete that you could necessarily present to a judge to articulate.
sadly, Senator, I've been on those scenes where we've lost them and we've had people get harmed.
Right.
I really do want to avoid that.
Right.
Thank you. Yep. Yes, you recognize.
Yeah, I just wanted to kind of reiterate a little bit on the part about them being able to skirt, the confinement thing. Is that my brother, he was very, very smart. He made the dean's list at the University of Houston until he became ill. And even then, when he was on his medication, he was very articulate and very smart. He self-taught himself on a lot of things. I mean, he was at age 21, computers weren't even out, but yet towards the end, I mean, he self-taught himself on everything. He was writing code and that kind of stuff. So when law enforcement would show up, because we knew if he was off his meds, he always found a way. He was always able to talk his way out of it. He would answer the questions that they, to their liking, and then they would leave. And then everything would just repeat itself. And so if family members, and like you were saying, is that, they've been to our place many times, knowing the history and that sort of thing, they could have, they can make the judgment to go ahead and have him taken in for immediate detention. And I think that this bill would help that.
Okay. Thank you.
Thank you.
Thank you, Mr. Chairman.
Thank you. Thank you all. Thank you all for your testimony. I see no one else is registered for public testimonies. Anyone here? Yes? Is that right? Yes. I called you earlier, so you're here. So Jan Lightfoot. Good morning.
Which side should I sit on?
Anywhere you want. And come forward, please. Did you register? Have you registered? We'll give you a card. You make sure you fill it out. I'll let you go ahead and come testify. But Ms. Lightfoot.
Yes, good morning. My name is Jan Lightfoot. I'm Dr. Lightfoot. I'm a licensed professional mental health provider and with an LPC and LCSW. I'm also a chaplain, CPE trained in the Southern Baptist Church. And I drove myself to an emergency room on Christmas Eve. I was having a headache and I was detained because I do have a occupational mental health diagnosis from a work injury in the federal government. So because of the stigma that's on mental illness, even my credentials could not override the abuse that's inherent in the system. Many persons who are designated to do these kind of work, they're not properly trained. And then to extend that would cause even more abuse. I'm talking about the original wording of SB 1164. We need to understand that anybody can be accused of anything, and psych intake has no record. It's often done without judicial oversight. We must have the judges involved, and we must have professionals involved with police detentions. Counseling is about relationship, rapport, and your own volition. And the question here is, can we heal people or bring healing if it's forced? I'm a proponent of mental health detentions. I'm the one that do them in my family and my church, but they have to be done ethically, and we cannot remove that it has to be dangerous. So what we end up doing is
You finish your sentence and then,
incarcerating non-dangerous people.
thank you. Thank you for your testimony. If you state your name, who you represent, your position on the bill.
Good morning. My name is Vesper Veda, and I'm on SB 1164. As someone who has personally experienced detention under duress due to a misinterpretation of my words in past, I understand how critical it is to have clear, consistent, and fair standards when it comes to emergency mental health detentions. I support the bill's emphasis on improving documentation and transparency. By requiring more specific and thorough documentation, this ensures that emergency detentions are justified. But it is also imperative that individuals receive timely and appropriate care. However, I have serious concerns about the bill's broader definitions of inability to recognize symptoms and capacity. This has the potential to create gray areas that could be misused or misinterpreted. When these terms are left open to individuals' interpretation, there is a risk for bias, assumptions influencing decisions about a person's liberty and mental health treatment. I've experienced such bias and assumptions in my hold in a facility where I was subjected to degrading procedures, including a strip search where I was made to squat and cough, and I was medically abused by having my medications for my documented disability withheld. Moreover, the bill may unintentionally make it more difficult to legally contest an unlawful detention. If we are to expand the standards under which someone can be detained, we must also strengthen protections to ensure due process and prevent misuse. By requiring prompt access to legal counsel and making sure patients are informed of their rights. We must also ensure proper training for professionals making these determinations and a commitment to meaningful evaluation, not just checking boxes on a form. The goal should be to protect both public safety and individual rights with equal care. Thank you.
Thank you. Thank you for your testimony. Any question, members? Thank you all very much for being here. So is there anyone else present which to testify on, for, or against Senate Bill 1164? Hearing none, public testimony is closed and we'll leave the bill pending. Chair lays out Senate Bill 2111. Chair sends up the committee substitute for Senate Bill 2111. Is there objection to adopting the committee substitute for Senate Bill 2111? Hearing none, so ordered. Recognize Senator Zaffarini to explain the bill and the committee substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 2111 relates to legal representation of indigent persons in this state and to proceedings before a magistrate, including the appointment of counsel for an indigent defendant. It is a recommendation of the Texas Indigent Defense Commission, of which Senator Brandon Creighton is a member. Members, this bill, the commission provides funding, oversight, and recommendations regarding civil and criminal public defense across the state. Based on the commission's recommendations, Senate Bill 2111 would expand legal access for indigent defendants at their first hearings, strengthen managed assigned counsel, or called MAC, programs, and public defenders' powers and support services, improve tools for defense work, and create fellowships and internships to increase legal representation in rural and underserved areas. These changes would improve fairness in the justice system by ensuring timely legal representation, enhance the quality and support of defense services, protect staff, and make indigent defense more sustainable and accessible statewide. Generally then, Senate Bill 2111 would allow public defenders to investigate the merits of habeas corpus claims before accepting a case, create guidelines for magistrate judges, allow limited scope appointment of attorneys to represent a defendant for magistrate proceedings, clarify the policies and judicial functions of managed assigned counsel programs, ensure appointed private attorneys can be reimbursed for reasonable travel costs of representing a client more than 50 miles away, allow courts to appoint public defenders to represent inmates when their original attorneys have conflicts of interest, and create an internship and fellowship program for law students and recent graduates who represent indigent defendants. It also would protect public defenders and MACs by removing personal identifying information from public tax appraisal rolls. The committee substitute differs from the bill as filed in that it would eliminate Section 9, which establishes a student loan repayment program for public defenders in high-need areas, and this was to reduce the fiscal note. And it would also eliminate Section 15, allowing the allocating the alcohol tax revenue to the Texas Fair Defense Fund. That was requested by Finance Chair Huffman, and I recognize her charm.
Members, any questions? Any questions? If not, the chair goes to invited testimony. The chair calls Scott Ehlers. For the record, your name, who you represent.
Good morning, Mr. Chairman, members. I am Scott Ehlers. I am the Executive Director of the Texas Indigent Defense Commission, and I am here as a resource witness to testify on the bill. I just want to give you a little background on our process regarding how we got here, how this legislative proposal got here. We have a consensus building process where we bring stakeholders together before every legislative session to talk about any ideas they may have to improve the indigent defense system. And we go through this consensus process, and then we bring any proposals that get through that process to our Policies and Standards Committee, who then approves those procedures or those proposals, and then it goes to the full governing board, who also approves those proposals. I don't think I have time to go through all of the provisions here, but I did want to highlight a couple that deal with TIDC operations in particular. Section 2 cleans up Article 1517, the magistration statute, and related to TIDC's operations, there's a record retention provision in there that was changed a few sessions ago that we would like to see improved in terms of a 2-year record retention process so that we can properly do our policy monitoring to ensure that counsel is appointed in a timely manner. And then on Section 9 and 10, as Senator Zaffarini had mentioned, there is the establishment of the Texas Public Defense Internship and Fellowship Program at TIDC. We'd like to establish this because of the severe attorney shortage crisis that rural Texas in particular is seeing. This is tied to exceptional items that we had in our budget that are in Article 11 at this point in both the Senate and the House. But nonetheless, I think this is that would be a program that could help rural Texas and indigent defense providers in rural Texas to increase the number of lawyers that are doing the work. So those are a couple of highlights that are directly related to TIDC's operations, but I'm happy to take any questions about any of the other provisions as well.
Members, any questions? Thank you very much for your testimony.
Thank you.
I see no one else registered as invited testimony. Invited testimony is now closed. Chair now opens up for public testimony. Chair calls Jim Bethke and Bradley Hargis. Begin on my right. If you state your name, who you represent, your position on the bill, and you have 2 minutes.
Good morning. I'm Jim Bethke, the Executive Director of the Bexar County Managed Sign Council Program. I'm also a member of the Texas Indigent Defense Commission. Mr. Chairman, Senator Zaffarini, members of the committee, thank you for hearing this bill. I'm here in reference to the Managed Sign Council provisions. There's a number of them. The Managed Sign Council program really is to provide support to attorneys that provide these services, to improve the delivery of the services the attorneys provide, and also provide oversight. Regarding the oversight provision, there's a section that makes some amendments to the enabling legislation under 26047 of the Code of Criminal Procedure, and that section outlines, and what we're attempting to do is provide clarity as to when our office needs to remove an attorney at times because of performance. Won't have the necessity of removing an attorney. What this will require is that our office provide clear guidelines on how this is going to be done so there are no surprises. There's another section pertains to vouchers. Our office processes between 30 and 35,000 vouchers annually from Class B misdemeanors up to first-degree felonies. The courthouse is open approximately 250 days out of the year. That means our office on average gets about 120 a day. The statute says that the director is to approve those vouchers. At the end of the day, the director is responsible for the approving vouchers. However, we wanted to clarify that other staff other than the director can also provide that. End of the day, the director is ultimately responsible. The last section I wanted to hit upon, since we have Mr. Hargis here, is dealing with the support. We have a number of attorneys that work.
All right, thank you. Thank you for your testimony. Proceed.
Chair, committee, senators, thank you for having me. I am Bradley Hargis, Executive Director of the Capital Area Private Defender Service, and I am the Travis County Managed Sign Council Executive Director. So like Mr. Bethke, I run the Travis County version. You've already heard a lot about what MACs are and how they've come to mature in the state, and you've heard about the process for this bill. So I'll highlight a few of them that are important to MACs. This collaborative process has created recommendations that will clarify the scope of representation at magistration, which is an important necessary step as local communities have started providing representation. It does not create a right for this or provide funding for it, but it does clarify for communities that are providing it the scope of that representation. It clarifies the supervision responsibilities from MACs, including the removals of attorneys, as Mr. Bethke outlines. It ensures records necessary for the functions of the MAC maintain attorney-client privilege and confidentiality. We are enlarging or morphing the classic attorney-client model in a managed sign council where we have supervision staff coming into the attorney-client relationship, and it's essential that while we're able to do our work, we maintain that confidence, that MAC oversight doesn't undermine any of the confidentiality, any of the privacy that these clients are entitled to. It ensures MACs have access to essential records in parity with other public defenders' offices. I could go on at length about improvements supported in this bill, such as the internship program, programs to increase the number of attorneys available in Texas to do this work, and that bill parts and encourage effective representation. I will go ahead and yield the rest of my time to any questions the committee might have, and thank you for your consideration and support of this bill.
Thank you, members. Any questions? Thank you all for being here. So seeing no one else signed up for public testimony, is there anyone here who wishes to testify on, for, or against Senate Bill 2111? Hearing none, public testimony is closed. We'll leave the bill pending. Thank you, Senator Zaffarini.
Thank you, Mr. Chairman and members.
Chair lays out Senate Bill 2383 and recognizes Senator Betancourt to explain the bill.
Thank you, Mr. Chairman. I don't bring a judicial work product this morning, but I do bring what I think is a great solution for a potential shortage in DPS manpower they're going to have. Over the next 2 years, we're going to have approximately 750 commissioned officers. They'll be able to retire from DPS, given the time-intensive nature of training, testing, and onboarding for new officers. We could potentially have a significant gap in staffing that will occur until the positions are backfilled. This bill creates a retention tool that can help mitigate vacancies until positions are filled with newly hired officers. Senate Bill 2383 would allow DPS officers who have recently retired in good standing to be allowed to apply for rehire with the department. It's obvious that retaining these experienced officers effectively and what would be limited second employment would be an important part of maintaining exceptional efficiency and performance we need in the department. I do have a resource witness, which is Colonel Taylor, who has conveniently had it up for the experience, so we can recognize him quickly.
Colonel? Just for the record, your name, who you represent.
Mr. Chairman, members, Jason Taylor, Lieutenant Colonel, Texas Department of Public Safety. Thank you, Senator Betancourt. Thank you all for your commitment to public safety. He hit all the high points. I'll be very brief. The attrition rate in DPS is approximately 200 commissioned officers per year. So with this tool, we'll be able to initiate our retire-rehire program and hopefully retain some of those veteran officers at the line level only, troopers, special agents, and Texas Rangers, and keep some of that experience in the agency.
Thank you. Any questions, members?
No, and thank you for your testimony and bringing it to my attention, Lieutenant Colonel. And the other point, not everyone's going to take this because, not everybody like Larry Satterwhite was going to want to come back for another hitch. Sometimes one hitch is enough, right?
You're exactly right.
All right, thank you.
All right, thank you. Thank you, Senators.
With that, the chair now closes inviting testimony, now opens it for public testimony. I see no one signed up to testify publicly. If there anyone present wish to testify on, for, or against Senate Bill 2383, seeing none, public testimony is closed. We'll hold this pending our voting. Very well. All right. Chair lays out Senate Bill 2797. Chair sends up committee substitute for Senate Bill 2797. Is there objection to adopting the committee substitute for Senate Bill 2797? Hearing none, so ordered. Recognize Senator Creighton to explain the bill and the committee substitute.
Thank you, Mr. Chairman. Members, this legislation is about reciprocal discovery. Reciprocal discovery is standard practice during criminal proceedings in 48 other states. Also, the military justice system and all federal courts. To give a little bit of background on current law, Mr. Chairman, discovery in criminal proceedings is largely one-sided, requiring prosecutors to disclose evidence to the defense while placing minimal reciprocal obligations on the defendant. In this imbalance, Texas stands almost alone in the nation. Our current system significantly restricts the efficiency of our trial courts and limits prosecutors' ability to ensure justice is done for both the defendant and the victim. The Michael Morton Act was a landmark reform in criminal law passed after a man wrongly spent 25 years behind bars for a heinous crime he did not commit. I voted for the Michael Morton Act, but at the same time, many of our district attorneys have come forward with an unintended consequence of that law, and this bill addresses that. While well-intentioned, Texas criminal discovery, as currently constructed, has sometimes strayed into trial by ambush. What we have unintentionally allowed to occur are circumstances where the defense may have evidence that is unbeknownst to the prosecution that proves that the defendant is innocent, but it is not presented until trial. This means that for months, prosecutors have been spending limited resources building a case against a defendant who's innocent of the crime that they're suspected of having committed. Meanwhile, the actual perpetrator is still free. Justice has not been served, and taxpayer dollars and time have been needlessly spent. Committee substitute for Senate Bill 2797 seeks to establish a transparent process, reasonable and fair pretrial evidence sharing between the state and the defense. And again, Mr. Chairman and members, this type of evidence sharing that occurs in 48 other states, this bill does not alter the existing discovery process mandated under the Michael Morton Act. It simply adds transparency and fairness in criminal proceedings. And Mr. Chairman, I know we have the Montgomery County District Attorney here, as well as representatives from the Chambers County District Attorney's Office and others to testify, and I appreciate your time and attention, Mr.
Thank you,
Chairman
Senator
and members.
Hinojosa.
Thank you, Mr. Chairman. Just a couple of questions, Senator Creighton. Right now, the state is required to only disclose expert witnesses, as I understand, but not all witnesses. Your bill requires for the defense to disclose all witnesses, depending on call at the trial.
Yes, it would require a written list of all witnesses the defendant reasonably expects to call at trial, and any written or recorded statements by witnesses, as well as any physical or documentary evidence that the defendant intends to present to the jurors. Again, this is just alignment with what 48 other states in the nation already do, and our military courts and our federal courts. There's no variation from that, and I know our testimony from our witnesses coming forward will provide distinguishing answers on that.
I'm not sure that we here in Texas always follow what 48 other states do. But my point is, but at the same time, while your bill requires for the defense to disclose all witnesses and a statement for what each witness will be saying in court, you don't have the same requirement for the state.
Well, I think that's what our testimony will provide today, Senator Hinojosa, but keep in mind again, should Texas, I don't think, is necessarily following any other state, but we have to decide what's right. Correct? I mean, we have laws in this state that are different than 48 other states that ultimately could harm the defendant. So in that respect, I think we're going to hear testimony today on how parity makes sense, not necessarily that we're following anyone, but we have to decide what is and is right in these situations. So.
Well, just, and also the state does not give the defense access to private locations of buildings and places, and you're requiring that of the defense side.
That's correct. Yeah, I mean, we're requiring exactly what would be alignment with what the rest of the nation offers on behalf of not just the victims, but also the defendants, and there's a reason for that, and I think we'll hear testimony on that today.
Well, it seems to me that if the state is required to just disclose experts, but not just regular witnesses like the defense is, I mean, that's really not a very balanced approach to discovery. And one more, I guess, just in general, it would seem to me that there are issues maybe with the Fifth Amendment right to self-incrimination. But I guess I'll listen to the testimony, but I'm just raising some of the issues and questions that I have since I've been on both sides, so to speak. And certainly the prosecution has a state and the authority and the resources of the state against a defendant who is not able to have the same resources equal to the state.
Well, this only applies to evidence a defendant intends to use at trial. So I think we'll have, excellent testimony on the reasons why we need to get in line with these other states, the federal courts and our military courts for this type of reciprocal discovery. Thank you, Mr. Chairman.
Thank you, Chairman, and thank you, Senator
Miles.
Creighton, for answering my questions, but I wait for the witnesses.
Senator Miles?
Thank you, Mr. Chairman. Senator Creighton, you keep saying get in line with the 48 other states, and you also keep saying doing what's right. And I'm interested in hearing from the witnesses as well. But in doing what's right, making sure that the defendant is presumed innocent until proven guilty?
And that still will be the case.
It'll still be the case?
Yes.
So if I'm a defendant, why would we require a defendant to turn over the evidence that the prosecutor is supposed to be doing the work on? I mean,
Again, Senator Miles, the bill only applies if the defense intends to introduce evidence. It doesn't require defendants to testify or waive their rights. It doesn't require any privileges under the U.S. or Texas constitutions to be waived, or the rules of evidence or statutes that are fully preserved on their behalf. And I think we'll hear testimony consistent with that today.
Mr. Chairman, I look forward to hearing from those witnesses.
Yes, sir. Thank you. Provided testimony, the chair calls up Brett Ligon.
It's Brett Ligon.
Ligon.
Yes.
Ligon. I'm going to get that right one day. Ligon. Was there here someone from Chambers County as well?
That's correct. Yes, sir.
I'm registered on the bill, but I'm not signed up to testify.
Okay. All right. We just wanted to give you a chance.
District Attorney Jack Rhodey, I believe. Mr. Rhodey from Galveston County.
Mr. Rhodey, if you can come forward. Are you registered? Have you signed? Yes. Please come forward, Mr. Rhodey. All right.
Good morning, Chairman Flores, Vice Chair Parker, Senators. Thank you very much. Senator Creighton, thank you very much for introducing this bill. For almost the last 30 years, trial in Texas, when you describe it to your witnesses and to victims, has often been referred to as trial by ambush. And when you're speaking to a victim, they say, well, who's going to testify? Who are they going to bring? You say, well, I don't really know, but it's possible that they may bring this witness or that witness. The United States Supreme Court has said over and over and over that trial should be the search for truth. But Texas courts, I believe often in the same way that Senators Hinojosa and Miles have said, hey, look, we don't always do what everybody else does. Texas courts have also said, but the trial for truth should also be balanced against a defendant's rights as well. And the way that Senator Creighton has written 2797, it's a beautiful piece of legislation because it absolutely does that. And in response to it, I will get to the two issues and the two concerns, and I love to hear your use of the word balancing, Senator Hinojosa, because I believe that you thought that the state is not required to turn over witnesses under 3914, and we are. So we're already doing that. Not only do we have to turn over witness statements, but we have to disclose what witnesses we are going to call to trial to begin with. And so when the trial starts, so one of your concerns that you shared with Senator Creighton was, wait a minute, you're asking the defense to do something to turn over either witnesses or witness statements to the state, and yet that wouldn't be fair. And it implied to me that you liked the idea of balance if the state was required to do it. Well, we're already required to do it, so I hope it satisfied that concern right off the bat, Senator. Secondly, Senator Miles, you had a concern in regards to the Fifth Amendment. Every challenge that has been made on constitutional grounds by every organization across the United States, the reciprocal discovery has been upheld specifically not only to Fifth Amendment rights, but to all the other rights to due process. So, for example, the courts have consistently held that reciprocal discovery does not violate the right to effective representation. It's mandatory. It's necessary. The right to a fair trial, right to due process, right to equal protection, right to remain silent, which is the Fifth Amendment right that is so important to everyone. Oftentimes in law enforcement, not only do you have a right, we wish that they would invoke the right to remain silent. And then lastly, the right to confrontation and cross-exam of witnesses. And so we have a packet that we have provided to the senators that speak to those very same concerns that you and I have. And I think I disclosed to this committee last time that not only have I practiced as a prosecutor for the last 17 years, but the 10 years prior to that, I was a criminal defense attorney representing defendants in court as well. Now, not only does Senator Creighton point out that the other 48 states, but even in Texas, we already have reciprocal discovery. And it's also amazing to most attorneys who practice family law, probate law, any type of civil law, that reciprocal discovery is already the law of the land in the state of Texas. Every lawyer already does it. And so when Senator Hinojosa and I share a common experience where we've done both prosecution and defense, but like most attorneys across the state of Texas, we know how to do discovery because we're already doing it in a will contest. We're doing it in a family law case. We're doing it in a probate case. We're doing it in plaintiff cases, torts, civil work. So all we're asking for is to prevent the trial by ambush. Now, I can also tell you this. I love the prosecutors across the state of Texas. I do. They're my brothers and sisters, but we don't always think the same, which is why our organization allows people to have dissenting opinions. But in this case, we provided a letter to Senator Creighton that talked about the fact that this was truly a nonpartisan bill. And I would like to indicate to this august body the fact that we had prosecutors from, I will pull this up, prosecutors across the state of Texas, Harris County District Attorney's Office, Dallas County District Attorney's Office, and I believe that their first assistant is going to testify here as well. Chambers County, Comal County, Calhoun County. There's an alphabetical order list here, but we'll skip all the C's, D's, and E's, and I'll go Cherokee, Dawson, Galveston, Grimes, Harris, and we'll end up with, I'll skip through, Senator Creighton has the letter, and we'll end up with Washington counties, Walker County, and Wilbarger County. It is truly a bipartisan piece of legislation. And lastly, we do want to get to the truth. This would also provide the opportunity to vet the state against inauthentic evidence being introduced. We're now in the world of AI. Every document can be faked. There are remedies for the defendant right now that if the state does something or a witness perjures themselves or offers testimony or evidence that turns out not to be valid, whether through a writ of habeas corpus or an appeal, the state has no such right. So if a piece of evidence is already admitted at trial, and I can give you examples of where that has occurred, and a jury relies on it in error because it turns out to be a piece of fake evidence or false testimony, the state doesn't have the opportunity at trial to investigate those claims. And when that results in an acquittal, those are victims who have lost their right as well. So at this time, I will turn my time over to my companion, Jack Rody, or answer any questions that the senators may have. So I'm here to testify on behalf of Senate Bill 2797.
Mr. Brody?
Mr. Chairman, members, thank you all this morning. My name is Jack Rody. I'm the elected district attorney for Galveston County. In my 15th year of that, I'm in my 25th year of being a prosecutor. I echo my colleagues' support of this bill. One of the greatest things about this, and Mr. Ligon focused on the fact that our justice system is meant to find the truth. And as prosecutors, we take an oath to see that justice is done. One of the things that this bill would require is that any defenses of alibi or information that might support alibis or a legal justification would be provided to the prosecutor. And any prosecutor who is keeping his duty to see that justice is done is going to fully explore that defense, because the last thing that a prosecutor wants to do is prosecute an innocent person. And so if we have the benefit of that information well before trial, then we have the opportunity to fully vet it. And if we're after the wrong person, then the time to decide that and discover it is early on, not in the middle of trial. And if for some reason the information that they're going to provide is not truthful, then we should have the opportunity to test its truthfulness, because our society puts trust in our justice system that the truth will be found out. And the time to find out that truth is before trial and not during or after. Thank you.
Thank you. Thank you for your testimony, Senator Huffman.
Yeah, a couple of questions. and about this legislation, and I'm curious to ask the prosecutors here. In my experience in the past, and many defense lawyers do fabulous jobs, whether they're appointed or hired. Vast majority do a great job. However, I think we've all seen, Senator Hinojosa, I'm sure you have the unprepared defense lawyers, right? Where you sit there and you kind of watch in dismay, right? And as a prosecutor, I felt that. I mean, if there's something out there that you don't know that they know, I feel like this protects the defendants because it actually requires their counsel to be prepared earlier and to be more focused on the defense. And to your point, if there is like an alibi, then if you're presented with that, you're going to send your investigators or law enforcement to follow up. Isn't that going to be the first thing you do? I mean, if there's an alibi, there's an alibi. Great. Well, let's dismiss the case and move on. I actually think this is a tool to help the defendant. I mean, maybe y'all don't see it that way. I can see your concern, Senator Hinojosa, but I know you've seen the unprepared defense lawyers who don't really have the outline of a defense.
Yes, Senator.
And to me, it kind of is a very good balancing way to make sure that the case is thoroughly investigated, both by, of course, the defense doesn't have the burden, but they do have to put on a defense. That's why they have a lawyer, right?
It can oftentimes be frustrating when you're representing the state to have to pull your punches or facing adversarial counsel that at best you would refer to as Mr. Effective Assistance of Counsel.
Yeah.
Not great, just barely effective. And oftentimes, and I believe that the provisions you're speaking to, Senator Huffman, is that when the state requests it, then the court has the ability to compel the defense attorney to comply with discovery. So in other words, the judge has the ability to tell the defense attorney, wait a minute, you have not complied with the discovery requirements. You should be, by implication, investigating your case. You should be able to turn over witnesses. Of the 100-plus trials, 120 trials over my career, somewhere in there, I've oftentimes had the case to where the state rests its case. The defense neither calls its defendant as a witness, which is proper, but doesn't muster any type of defense. And oftentimes, you don't know if it's a matter of strategy, or you don't know if it's a matter of preparedness, or the fact that that's just the best that they had, which was just to merely challenge the state's case. In this case, it's clear it would remove it as a lack of strategy. And so one of the things that there is a writ of habeas corpus deals with whether or not the effective assistance of counsel goes into the realm of whether or not it was strategy, to not call any witnesses whatsoever as a defense attorney, as opposed to, I just wasn't prepared. It does give the court the opportunity to look at a defense attorney and say, wait a minute, we're 30 days out of trial. You haven't turned over a witness list. You haven't turned over your expert witnesses. You've provided no statements, anything that you intend to rebut the state's case. And it would make a defense attorney say, Judge, that is a matter of strategy. And so we don't have any witnesses. We plan on challenging the state's case. Great, fine. That's fine. On the other hand, if they do, it would certainly give them the opportunity to go, oh, man, we better at least have the defendant's mother to come in here and say something nice about him for punishment. So it is a effective tool for judges. And I have to speak up on behalf of the judges of Montgomery County. I know we're one county out of 254 counties. The judges of Montgomery County want to get it right. Probably one of the most ardent judges in the county, when he was a first assistant, became a district court judge. And I said, what's the biggest change? And he said, probably the biggest change is how much I work every day to make sure that the defendant is truly represented in a way that he should be. And so it does give good, conscientious judges the ability to make sure that the defendant's rights are actually fully represented by defense attorneys that either by fee or by favor or by a natural reluctance to actually muster a case on their behalf. An adversarial system is a good system.
If I could, I would agree. And I will say, again, we're not trying to disparage any lawyers at all. That's not my intent. I also know that some of the defense lawyers have a very heavy caseload. And I get it. I mean, they get appointed or whatever, or they're hired and they take on, and it may slow them down a little if they actually have to look at these cases and, go ahead and at a timely, an appropriate time to, think about it, what their defense strategy will be and so forth. And I'm just not sure that is being done all the time, and I think this would help.
And lastly, the national average for cases tried. So we will file approximately 10,000 felony cases this year and about 7,000 misdemeanor cases in a jurisdiction of 800,000 people. The national average of cases that actually get tried is about 1 to 1.5% of cases. So out of 7,000 felony cases, if you try 70 cases in a year, then you're hitting the national average. In Montgomery County, we've never tried 70 felony cases in a given year. I think 64 is the most we have. So it is a burden for trial purposes. It's not a burden for the 92% of other cases that are resolved either through a dismissal or through a plea. There are only 3 flavors in criminal law: trial, dismissal, or a plea. And it shows how lack of creativity I've had in my career as an attorney. I only do 3 things, and I've done the same 3 things for the last 29 years. I'm either pleading something, dismissing something, or I'm trying something. And in almost that career, it's about 120 trials. So it's a very, 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 very small population that we're asking for parity in discovery rights.
I would just say I think it will increase your workload too, because you'll have more information early on. But I do believe that it would also result in more dismissals because you have more information up front that makes you investigate your case a little bit more too. It could go either way, but I do think it leads to the truth, which, to your point, is what
Yes, Your Honor.
that we should try to do. And so that's why I'm supportive. It's a great bill, Senator Creighton.
Senator Hinojosa.
Thank you, Madam Chair. I agree with you. This is not a Republican versus Democrat, not a partisan bill. I don't even know why you went there, because it isn't. It's more in terms of protecting the rights of a defendant under the Constitution. But several points. One, as I read the rules of evidence, the prosecution is not required to disclose all its witnesses, just expert witnesses, while the bill itself requires the defense to disclose all witnesses. And I probably do agree with the overall intent of the bill, but some of the provisions are not parity. I think it needs a little bit more work of the bill itself. I'm not sure that just the way it's written right now, we get there. But and I don't want to get into the issue whether the criminal defense lawyer is competent or not competent. I do know that most of them plead. Some don't pay the proper attention, and they just becomes like a assembly line, pleading them guilty, pleading them guilty, pleading them guilty, and don't do justice to the defendant. We have that issue and problem in many of our courts. But again, there are certain areas of this bill that that probably need a little bit of work on it, and we'll see what the at some point I would like to hear Shannon's take on this bill, but I guess we'll listen to the rest of the testimony and see what they say.
Yes, sir.
Any other questions, members? Thank you all for your testimony. Seeing no one else signed up for invited testimony, Chair now opens for public testimony. Chair calls Jason Hermas and David Gonzalez. We'll begin with you.
All right.
State your
thank you.
name, who you represent, your position on the bill. You have 2 minutes.
Thank you, Mr. Chairman, and thank you to the committee senators. My name is Jason Hermas. I represent the Dallas County Criminal District Attorney's Office, and I'm here in support of Senate Bill 2797. I'm not going to go over and waste your time with being redundant with what my colleagues just told you. I share their sentiment. I share their values. And I think with Senator Huffman, I recognize the same utility and benefit that this particular bill would provide. I just wanted to make you all aware of 1 or 2 things. When the Michael Morton Act was first being proposed and developed through this legislature, it contemplated reciprocal discovery. I don't know if you all knew that. The basis from the very beginning was that our system of justice was going to be a pursuit for the truth and was going to wholeheartedly embrace reciprocal discovery to that end. Unfortunately, it didn't come to fruition. Now, I'll tell you, I've been a prosecutor for 23 years. I've tried hundreds of cases. I've tried cases before the Michael Morton Act, and I've tried cases after it. I believe that fortunately, what Michael Morton Act did was it took unfair advantage, unfair surprise out of the playbook of prosecutors for those that were inclined to do it. We put everything on the table. This is our case. We're going to beat you or we're not, but you're going to see what's coming. Unfortunately, what it didn't do is it did not take that element of gamesmanship out of the hands of the defense. And with our defense colleagues, what they will do is they will use unfair surprise as unfair advantage. And that's not how this should be. If there's an alibi witness, Senators, I have plenty of cases. If that defendant is innocent, efficiency in the system and justice will compel me to move that case and dismiss it if there's a legitimate alibi witness. But if the defense is allowed to continue to bring that up only after jeopardy has attached, and I can't challenge it because I've never heard it before, well, injustice will result. Thank you very much for your time.
Thank you for your testimony.
Good morning. My name is David Gonzalez with the Texas Criminal Defense Lawyers Association, testifying in opposition of 2797. And the reason is that we don't stand as equals in the courtroom. I wish we had a police force and crime labs and a grand jury, but the Michael Morton said that's the government's funding, and so both sides get access to what an independent investigator does, because we're not on the scene. We're not taking those first statements. And so the Constitution recognizes that we are not equal parties, but counterweights. And so whether it's the presumption of innocence, the burden of proof, the requirement of an open public trial, a unanimous jury, all of those recognize that we aren't like family law attorneys. We are not like personal injury attorneys, wills and estates attorneys, where we're equal. We're not. And so the reasons we have opposition philosophically is that Texas has always resisted expansive government intrusions on individuals. The federal government in 41 states have a state income tax. We don't. There's a lot of things that are different in the federal rules. And so for our practitioners that practice in federal court, we don't have to give notice of all of our defenses in federal court. The reciprocity is far greater in this bill. Likewise, under 3914, there's things like affirmative defenses that are true that we must give and experts that we do share. But it's a bit more than that. And I think our main concern is that the government shouldn't demand a defense file in preparation for their trial. Certainly, if any citizen's accused of an IRS tax audit, the IRS doesn't demand their tax audit defense prior to federal trial. And right now, we just think it's going to trigger far more litigation than less, as well as stop the legitimate investigation that defense attorneys do for risk that it gets turned over. Thank you.
Thank you very much for your testimony. Members, any questions? Thank you all very much.
Thank you, sir.
Seeing no one else signed up for public testimony, is anyone present that wishes to testify on, for, or against Senate Bill 2797? Hearing none, public testimony is closed. We'll hold this pending. Senator Creighton. Chair lays out Senate Bill 2798 and recognizes Senator Creighton to explain the bill.
Thank you, Mr. Chairman. Members, the nature of financial fraud makes detection inherently difficult, as perpetrators deliberately conceal their actions in committing this fraud. Victims often do not realize that they've been defrauded until well after the offense occurs, and only then do they report it to law enforcement. As the statute of limitations clock begins at the time of the offense, not upon discovery by the victim, all too often does the statute of limitations expire before law enforcement can even fully conduct an investigation, or prosecutors being allowed to have the time to seek justice for the victim. These investigations are time-intensive. They're frequently requiring the acquisition and review of out-of-state banking and credit card records. During this process, additional victims are commonly discovered, expanding the scope of the investigation and the time required. Under current law, statute of limitations for certain financial fraud crimes in Chapter 32 of the Penal Code are applied inconsistently. Some offenses, like credit card and debit card abuse, are given a 7-year statute of limitations. However, the offense of fraudulent use or possession of credit card information is only given a statute of limitation of 3 years. These discrepancies result in victims of similar crimes, private citizens and financial institutions being treated differently under the law. This legislation extends all financial crimes, Mr. Chairman, under Chapter 32 of the Penal Code with a 3-year limitation to a 7-year statute of limitations. This uniformity is necessary to give victims, law enforcement, and prosecutors the time they need to have these cases reported, investigated, and disposed. Thank you, Mr. Chairman, members.
Thank you. Members, any questions? We have we're now open for invited testimony. Nancy Herbert. Your name and who you represent, please, and...
Good morning. My name is Nancy Hebert. I am here on behalf of myself and the Montgomery County District Attorney's Office. I have worked there for over 21 years, almost 22, and I work for our elected official, District Attorney Brett Ligon. And thank you for having me, and thank you, Senator Creighton, for this bill. It's a pretty straightforward bill. We have I've worked in I'm chief prosecutor for financial crimes, and I see fraud crimes every day. It's pretty straightforward that some of the crimes only have a 3-year statute of limitation, some have 7. And it's random and arbitrary as to why that is. Some of the protections afforded, for instance, for a banking institution are 7 years, but hindering secured creditors, which applies to individuals or agencies or institutions, is only 3. So this would better allow clarity and uniformity in how the fraud provisions are timed as far as statute of limitations, and allow us also discovery for the actual fraud offense. Many times, like Senator said, there's concealment. We don't know this crime has occurred. And then only when an individual finds out the crime occurs, and then get to start our investigation. And it is a complex investigation that takes over a year sometimes. You have to go subpoena bank records. Then once you get those bank records, go through them, and then get additional bank records under subpoena to try to uncover and investigate these claims. Then they make their way to the district attorney's office for us to prosecute. Numerous examples where claims have expired before they can be fully investigated or even discovered. And it will also protect our citizens, including the elderly, who carry a great deal of shame in coming forward and even bringing this to law enforcement's attention, and then trying to have enough time to then go through and do the investigation. Thank you. I'm here for any questions you may have.
Thank you. Members, any questions? Thank you very much for being here.
Thank y'all.
Thank you for your testimony. Seeing no more invited testimony is now closed. Chair now opens for public testimony. The chair sees no one signed up for public testimony. Is anyone here present wishes to testify on, for, or against Senate Bill 2798? Hearing none, public testimony is closed. We'll leave this pending the vote here in a little bit.
Thank you, Mr. Chairman, members.
Chair lays out Senate Bill 2196 and recognizes Senator Miles on behalf of Senator Johnson to explain the bill.
Thank you, Mr. Chairman. Senate Bill 2196 amends the Code of Criminal Procedures to extend the period in which the magistrate orders for emergency protection remaining in effect to allow more time for the victim to arrange critical resources, seek shelter, and secure finances for further protection of their family. Magistrate Order of Emergency Protection, MOEP, is protective mechanism for victims and their families after the offender is arrested for committing family violence, sexual assault, sexual abuse, indecency assault, stalking, or trafficking. Under current law, MOEPs are issued for options of 31, 61, or 91 days. However, MOEPs do not provide enough time for a victim of a crime to ensure adequate protection and relocate necessities and is necessary and resources in their lifetime. SB 2196 amends Article 17.291J, the Code of Criminal Procedures, to extend MOEPs in increments of 30 days for each respective time frame from 31 to 61 or 91 days to 61, 91, or 121 days, Mr. Chairman. There is one witness available, Ms. Jean Muge with the Texas County of Family Violence. Is she here?
Thank you. Any questions for Senator Miles? So invited testimony is now open. Jennifer Muge. I hope I pronounced that correctly.
I hope I pronounced that correctly too, ma'am.
I'm just following the senators.
It's Mudge.
I'll follow.
What's your name? Who do you represent?
Hi, my name is Jen Mudge. I'm a public policy manager with the Texas Council on Family Violence. We're the statewide coalition of family violence programs across the state and in your districts. So I'm here in support of SB 2196. Thank you for the opportunity to speak, and thanks to Senator Johnson for authoring the bill. So this bill has a powerful but simple safety change. As Senator Miles mentioned, it would extend the duration of magistrates' emergency protection orders, or MOAPs, when the defendant is arrested for family violence or a list of several other offenses. This simple shift is easily a window that could save lives. By extending the period of a MOAP, the criminal justice system begins to better reflect the ongoing reality and needs of survivors. In the aftermath of an assault, a survivor often needs time. They may need time to get connected with a family violence center and create a safety plan, or to secure new housing or relocate. They may need time for medical care if they have sustained injuries before they can really even think about next steps. Maybe they need time to get into counseling. There's a lot of other things that survivors might need time for as well, but having that longer duration provides vital time for the survivor to make these important yet emotionally difficult decisions. And it would give time for survivors to seek out what they need without the fear of an order expiring before they can even get their bearings. I think the extended duration also acknowledges the impact of trauma, and that survivors may need time to at least initially process what has happened to them before they can take next steps. Ultimately, providing this protection could be the difference between a survivor staying safe and them having to return to an abusive partner or even be re-victimized. So I would encourage you to support SB 2196 and update our protective measures in alignment with the real needs of survivors. Thank you for your time, and I can take any questions.
Members, any questions? Thank you very much for your testimony.
Thank you.
I see no more invited witnesses. So it's invited witnesses closed. Chair now opens for public testimony. I see no one signed up to testify publicly. Is anyone here present wish to testify on, for, or against Senate Bill 2196? Hearing none, public testimony is closed, and we'll leave the bill pending for voting here. And just after, so members, we got a couple, just two more bills, and then bear with me, and we'll vote. We'll vote. Is that all right with everyone?
Yeah, I'll talk fast.
Well, you got this is Senator Huffman Day.
Yes, apologize. Kind of stacked up. Sorry about that.
That's okay. That's okay. Senate Bill 11. The chair lays out Senate Bill 1152 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. There are concerns that offenders who repeatedly engage in small-scale drug distribution can continuously accumulate multiple pending state jail cases for minor drug deliveries. Until offenders have been convicted of 2 prior state jail offenses, prosecutors are limited to a low-level sentencing range, even if the combined amounts would otherwise qualify as third-degree felony charges. And we see this a lot with, because they're all released on bond, low bonds, personal bonds that go back out that continue to reoffend, and you'd be shocked at some of the numbers that of pending cases. Senate Bill 1152 creates a new third-degree felony offense if a person during a 12-month period engages in 2 or more instances of manufacturing or delivery of a controlled substance. It also clarifies that jurors do not need to unanimously agree on the specific instances of conduct, the dates, or the counties in which the offenses occurred. However, they must unanimously agree that the defendant committed 2 or more qualifying offenses within the 12-month period. And I'd like to thank Waller County DA Sean Whitmore for working with me on this important change to crack down on repeat drug delivery offenders.
Thank you. Members, any questions? There's no invited testimony. So the chair now opens for public testimony. There is no public testimony registered. So is anyone here present wish to testify on, for, or against Senate Bill 1152? Hearing none, public testimony is closed. We'll leave the bill pending our voting here in a few minutes. Chair lays out Senate Bill 1896. The Chair sends up committee substitute for Senate Bill 1896. Is there any objection to adopting the substitute for Senate Bill 1896? Hearing none, so ordered. Recognize Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. After an arrest for certain offenses, a magistrate can issue an order of emergency protection for the victim and the victim's family or household members. The purpose of the magistrate's order is to prevent the defendant from inflicting further harm on the victim after the defendant is released. Senate Bill 1896 requires a law enforcement officer to provide to the magistrate the relevant information regarding the arrested person that is necessary for the issuance of a magistrate's order for emergency protection. This information is the same information that the arresting officer's agency will ultimately be responsible for submitting to the Texas Crime Information Center database. When the information is not provided up front, it requires a magistrate to seek the necessary information and delays their ability to issue these potentially life-saving orders. So it's just, and the committee sub just makes some minor clarifications and conforming changes. This was just something that was needed to just facilitate the process of issuing these emergency orders. That's it.
Thank you. Members, any questions? Chair now opens for divided testimony. Chair calls Karen Diaz, Judge Karen Diaz. Good morning.
Mrs. Gidget, she's my service dog.
Oh, that's okay.
She may squawk in a minute because my heart's beating.
That's okay. Just she calms you down. That's good, Your Honor. So, your name, who you represent, and you may proceed with your
Chairman
testimony.
Flores, Vice Chairman Parker, and members of the committee, good morning.
Morning.
I am Judge Karen Diaz. I've been a Justice of the Peace, Municipal Court Judge, and a Texas Magistrate for 24 years. I'm here today on behalf of myself and the Justice of the Peace and Constable Association testifying in favor of Senate Bill 1896. Let me begin with thanking Senator Huffman and her staff for their tireless work on this bill. Magistrates have an obligation to issue a MOAP, which Senator Miles spoke of earlier, and offenses involving family violence that result in serious bodily injury or the use or exhibition of a deadly weapon. It is also within our discretion to issue one when the defendant is under arrest for sexual assault, trafficking, or any other family violence offense. A MOAP is meant to protect the victim and any other protected persons necessary by prohibiting the arrested person from committing any further acts of family violence or assault, from going so many yards within their home, work, or school, and also prevents them from possessing a firearm. It must be issued at the time the arrested person is brought before the magistrate, and the victim will not be present at this time. How are we to know this information when it is not included on a probable cause statement or as part of the arrest warrant? We must rely on law enforcement to gather this information for us. After last session, OCA worked with stakeholders across the state to create standardized forms for the application and issuance of these protective orders. They are now uniform and used by victims, law enforcement, and the courts. They have also provided training on them all across the state, and we are definitely headed in the right direction. Senate Bill 1896 is a common sense bill. It's really just a way to codify what is already a best practice and to encourage law enforcement, who are the first responders on the scene and in the best position to obtain the needed information, to simply provide it to the magistrate. For the magistrate, it can be extremely time-consuming and most times impossible to track the information down at that time and to give the victim the protections they deserve and the defendant the due process they are entitled to. One of the forms available on the OCA website is the TCIC Protective Order Data Entry Form. If Senate Bill 1896 becomes law, then OCA can easily move from a discretionary to a mandated form, and it will be an efficient way for law enforcement to collect pertinent information at the time of arrest or during their investigation. The thought being that the form could be transmitted with the body for an on-view arrest or as part of the warrant confirmation if the defendant is arrested at a later date in another jurisdiction. Ultimately, the hope is to provide us with the necessary information up front so we can effectively do our job in issuing these protective orders at the time of magistration and ensure entry into the TCIC registry and, most importantly, protect victims of family violence. Thank you from the bottom of my heart for considering this bill, and I'm happy to answer any questions.
Members, any questions? Senator Huffman.
No, I'm fine. I like this one.
Thank you for being here.
Yes, sir.
Thank you for your testimony, ma'am.
Thank you. Let's go, Gidget.
Seeing there's no more invited testimony is now closed. The chair now opens public testimony. Or showing no one registered for public testimonies. Anyone here wish to testify on, for, or against Senate Bill 1896? Hearing none, public testimony is closed, and we'll hold the bill pending, and I think that concludes what we wanted to go through today, and we will go now, if members, if it's okay with you all, we'll start the vote. Just bring it up and then go to there. Just. So we left it pending? Yeah. And so we voted, so we bring it back up, vote it out.
Thank you, Mr. Chairman. Members, Chair now pulls up as a member of pending business, Senate Bill 2570. Chair moves that SB
2570.
2570.
That's peace officer.
By Senator Flores.
Substitute. Is it substitute? It was laid out last. It's just, we're going to go straight to the vote. Yeah, good.
All right. The chair now moves up Senate Bill 2570. It's substitute. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Present, not voting.
Okay. Senator Huffman?
Aye.
Senator Miles?
Nay.
Senator King?
Aye.
Senator Hagenbu?
Aye.
5 ayes, 1 nay, 1 present, non-voting.
There being 5 ayes, 1 nay, and 1 P and V, the committee substitute for SB 2570 will be reported to the full Senate with a favorable recommendation.
Thank you, Mr. Vice Chairman. The chair brings up as a matter of pending business Senate Bill 330. The chair moves that Senate Bill 330 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles?
Aye.
Senator King? Senator Hagenbu?
Aye.
7 ayes, no nays.
That'd be 7 ayes, 0 nays. Senate Bill 330 will be reported to the full Senate with a favorable recommendation. Do you wish to go local?
Sure.
Senator Parker moves that Senate Bill 330 be recommended for local and uncontested calendar. Any objection? Hearing none, so ordered. Chair brings up Senate Bill 663 as a matter of pending business. Chair moves that Senate Bill 663 do not pass, but that the committee substitute for Senate Bill 663 adopted in lieu thereof be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman? Senator Miles?
Aye.
Senator King?
Aye.
Senator Hagenbu?
Aye.
7 ayes, no nays.
Every 7 ayes and no nays. The committee substitute for Senate Bill 663 will be reported to the full Senate with a favorable recommendation. Senator Huffman, you wish this bill be recommended for local? Senator King recommends a committee substitute for Senate Bill 663 be recommended for local and uncontested calendar. Any objection? Hearing none, so ordered. Chair brings up as a matter of pending business, Senate Bill 1020. The chair moves that Senate Bill 1020 do not pass, but that the committee substitute for Senate Bill 1020 adopted in lieu thereof be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles?
Aye.
Senator King? Senator Hagenbu?
Aye.
7 ayes, no nays.
There be 7 ayes and 0 nays. The committee substitute for Senate Bill 1020 will be reported to the full Senate with a favorable recommendation. Senator Huffman, you wish this bill to be recommended for local? Yes, sir. Senator Parker recommends that the committee substitute for Senate Bill 1020 be recommended for local and uncontested calendar. Any objection? Hearing none, so ordered. Chair brings up as a matter of pending business Senate Bill 1152. The chair moves that Senate Bill 1152 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Nay.
Senator King. Senator Hagenbu. 6 ayes, 1 nay.
There be 6 ayes and 1 nay. The Senate Bill 1152 will be reported to the full Senate with a favorable recommendation. So we'll go to the floor. Chair brings up as a matter of pending business Senate Bill 1164. The chair moves that Senate Bill 1164 do not pass, but that the committee substitute for Senate Bill 1164 adopted in lieu of thereof be reported to the full Senate with a recommendation that it do pass favorably and be printed. Clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King. Senator Hagenbu.
Aye.
7 ayes, no nays.
There be 7 ayes and no nays. The committee substitute for Senate Bill 1164 will be reported to the full Senate with a favorable recommendation. Senator Miles, I do recommend the committee substitute for Senate Bill 1164 be recommended local and uncontested calendar. Is there any objection? Hearing none, so ordered. Chair brings up as a matter of pending business Senate Bill 1896. The chair moves that Senate Bill 1896 do not pass, but that the committee substitute for Senate Bill 1896 adopted in lieu thereof be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King. Senator Hagenbu.
Aye.
7 ayes, no nays.
There were 7 ayes and no nays. The committee substitute for Senate Bill 1896 will be reported to the full Senate with a favorable recommendation. Senator Huffman, you wish to go local? Senator Hinojosa recommends a committee substitute for Senate Bill 1896 be recommended for local and uncontested calendar. Is there any objection? Here none. So ordered.
This is the TID thing. I think Huffman okay with the score. Ask her.
Chair brings up as a matter of pending business Senate Bill 2111. The chair moves that Senate Bill 2111 do not pass, but the committee substitute for Senate Bill 2111 adopted in lieu thereof be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King. Senator Hagenbu.
Aye.
7 ayes, no nays.
There be 7 ayes and no nays. The committee substitute for Senate Bill 2111 will be reported to the full Senate with a favorable recommendation. Senator Hagenbu recommends that the committee substitute for Senate Bill 2111 be recommended for local and uncontested calendar. Is there objection? Hearing none, so ordered. Chair brings up as a matter of pending business Senate Bill 2196. The chair moves that Senate Bill 2196 be reported to the full Senate with a recommendation that it do pass favorably and be printed. Clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King.
Aye.
Senator Hagenbu. 7 ayes, no nays.
There be 7 ayes and 0 nays. Senate Bill 2196 will be reported to the full Senate with a favorable recommendation. Yes. Senator Miles recommends that Senate Bill 2196 be recommended for local and uncontested calendar. Is there any objection? Hearing none, so ordered. Chair brings up as a matter of pending business Senate Bill 2371. The chair moves that Senate Bill 2371 do not pass, but that the committee substitute for Senate Bill 2371 adopted in lieu thereof be reported to the full Senate with the recommendation that it do pass favorably and be printed. 2371.
Nichols rated
Nick-
skimmers on electronic.
Okay, I'm good.
Okay. But that the committee substitute for Senate Bill 2371 adopted in lieu thereof be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Hoffman. Senator Miles.
Aye.
Senator King. Senator Hagenbu. 7 ayes, no nays.
7 ayes and 0 nays. The committee substitute for Senate Bill 2371 will be reported to the full Senate with a favorable recommendation. Senator Huffman recommends the committee substitute for Senate Bill 2371 be recommended to local and uncontested. Is there any objection? Hearing none, so ordered. Chair brings up as a matter of pending business, Senate Bill 2383. The chair moves that Senate Bill 2383 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King. Senator Hagenbu. 7 ayes, no nays.
There'll be 7 ayes and no nays. Senate Bill 2383 will be reported to the full Senate with a favorable recommendation. Senator Parker recommends that Senate Bill 2383 be recommended for the local and uncontested calendar. Is any objection? Hearing none, so ordered. Chair brings up as a matter of pending business Senate Bill 2581. The chair moves that Senate Bill 2581 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King.
Aye.
Senator Hagenbu.
Aye.
7 ayes, no nays.
There'll be 7 ayes and no nays. Senate Bill 2581 will be reported to the full Senate with a favorable recommendation. Senator King recommends that Senate Bill 2581 be recommended for local and uncontested calendar. Is any objection? Hearing none, so ordered. Chair brings up as a matter of pending business Senate Bill 2797. Chair moves that Senate Bill 2797 do not pass, but that the committee substitute for Senate Bill 2797 adopted in lieu thereof be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
No.
Senator Huffman.
Aye.
Senator Miles.
Nay.
Senator King. Senator Hagenbu.
Aye.
5 ayes, 2 nays.
There be 5 ayes and 2 nays. Committee substitute for Senate Bill 2797 will be reported to the full Senate with a favorable recommendation. This one will go to the floor.
I did some work.
Chair brings up as a matter of pending business Senate Bill 2798. The chair moves that Senate Bill 2798 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King. Senator Hagenbu.
Aye.
7 ayes, no nays.
There be 7 ayes and 0 nays. Senate Bill 2798 will be reported to the full Senate with a favorable recommendation. Senator Hagenbu recommends that Senate Bill 2798 be recommended for local and uncontested calendars. Any objection? Hearing none, so ordered. I think that does it. I think that does it for today. I want to thank everyone for being here, and I appreciate it. If I have no more business, the committee will stand in recess subject to the call of the chair.
Thank you, Mr. Chairman.